Señor rector, cuando quiera.
Gracias, Chema. Muy buenos días y un saludo muy cariñoso, muy afectuoso para todos los que estáis siguiendo este congreso COGENS que se va a celebrar pues hoy y mañana de forma virtual, porque la pandemia que afecta a todo, también a las posibilidades de vernos y encontrarnos, y también, como no, a las relaciones laborales, que es parte del objeto de este seminario, pues nos han complicado la existencia. La verdad es que este proyecto pues, es un proyecto de nivel internacional, que abarca 16 países europeos y surge de pues, unos proyectos, una red previa donde pues, se trataba de afrontar el impacto de la crisis en las relaciones laborales. La verdad es que, bueno, hemos salido o estábamos saliendo de una crisis económica durísima que empezaba allá por el año 2010, y cuando estábamos empezando a asomar la cabeza, empezando a ver la luz, pues nos apareció, pues se nos cruzó por el medio esta nueva crisis sanitaria que pues ha venido a trastocarlo todo de forma absolutamente imprevista. De una parte, trastocar la forma en que nos relacionamos. Seguramente este congreso pues, podría haberse celebrado de forma presencial aquí en Santiago de Compostela, y especialmente en un año como este, que es Año Santo. Las circunstancias nos lo impiden y, por tanto, hay que utilizar estas soluciones tecnológicas, que es verdad que nos impiden estar cerca, pero nos permiten llegar cada vez más lejos, y estoy seguro que eso, por un lado, pues sí favorece el que muchos de vosotros podáis seguir desde cualquier parte del mundo pues los trabajos de estos 2 días de reflexión. Pero esta nueva crisis, la anterior y esta sanitaria, han impactado también duramente en las relaciones, en las propias relaciones laborales. Qué duda cabe que uno de los grandes cambios, de los grandes saltos que se han generado en este escaso año y medio de pandemia ha sido pues, la digitalización, la transformación digital, o como queramos llamarle. Esto que ha permitido que dispongamos de estas herramientas que nos permiten comunicarnos a distancia, que nos ha permitido dotarnos de instrumentos para poder también trabajar a distancia, pues está cambiando, yo creo, que el panorama también de las relaciones laborales. Lógicamente yo no voy a entrar mucho en esto porque no es mi ámbito de conocimiento, pero qué duda cabe que conceptos como seguramente pues, el puesto de trabajo, jornada laboral, pues habrá que reformularlos, revisarlos a la luz de esta nueva realidad, donde pues en buena medida se van a poder desarrollar los trabajos sin estar físicamente en el puesto de trabajo que corresponda. Bien, pues eso yo creo que es uno de los grandes retos que tenía por delante este proyecto internacional de investigación. Buscar cómo, pues en este caso, la negociación colectiva puede ser la vía más rápida, más inmediata para dar solución a estas nuevas demandas, a estas nuevas necesidades de las relaciones que surgen de este nuevo contexto de las relaciones laborales en un marco absolutamente digitalizado. Seguramente las soluciones legislativas tendrán que llegar también, pero es seguro que van a tardar un poco más, y tendrá que ser pues, esta vía de la negociación, del acuerdo entre empresarios y trabajadores, por donde se trate de dar solución a estas nuevas realidades. Sirva como un ejemplo, pues en nuestra universidad acabamos de firmar un acuerdo con todas las representaciones sindicales de los trabajadores para darle salida, para dar un marco básico a estas nuevas posibilidades de teletrabajo en nuestra institución. Y esto no es una anécdota, es algo que pues, hay que generar y se va a generalizar en el conjunto de nuestras empresas. Bien, pues yo pues estoy muy satisfecho y absolutamente encantado de que la Universidad de Santiago forme parte de este proyecto, de que asuma a través del profesor Miranda Botol la coordinación juntamente con la Universidad de Viena de este proyecto y pues les agradezco a todos el trabajo, porque cualquier iniciativa de esta supone un esfuerzo enorme que muchas veces solo tiene la satisfacción de poder ampliar el marco de conocimiento, de la satisfacción de la investigación, del trabajo hecho y de aportar soluciones que puedan contribuir a mejorar, en este caso, el marco de las relaciones laborales. Por mi parte, pues poco más. Insisto en el reconocimiento y agradecimiento. Además al profesor Miranda Boto, permítame que tenga un saludo especialmente afectuoso para los profesores de nuestra universidad, la profesora Maneiro Vázquez, Santiago Iglesias, Barros Valdar y Pérez del Prado, por el trabajo hecho, por representarnos tan bien en este proyecto internacional y por mantener pues esta ilusión y estas ganas imparables de hacer cosas que muchísimo agradecemos y que son muy envidiables. Solo me resta desearles a todos que pues estas dos jornadas de reflexión pues sean unas jornadas fructíferas. Se trata precisamente de poner de manifiesto los resultados del trabajo de todos estos años, de todo este proyecto, y seguramente pues va a ser muy bien recibido por todos los destinatarios, representantes de trabajadores, empresas, nuestros legisladores deberán tenerlo en cuenta a la hora de dar la solución adecuada a esta nueva realidad. Y esto es una de las grandes misiones que tenemos también en la universidad, y esto es transferencia de conocimiento también. Es decir, generar conocimiento, estudiar y trasladar los resultados de esa investigación, de ese estudio, para que los agentes económicos pues, los puedan hacer efectivos en sus respectivos ámbitos. Simplemente pues añadir que, como les decía al principio, pues la pandemia no nos permite celebrar esto presencialmente como nos hubiese gustado, pero permítanme que les reitere pues una invitación para que puedan visitar nuestra universidad, para que puedan visitar Santiago de Compostela pues en cualquier momento. Estamos todos viendo con ilusión cómo la crisis sanitaria parece que evoluciona muy positivamente y ojalá pues pronto tengamos ocasión de poder recibirles aquí en Compostela y en nuestra universidad como unos peregrinos más. Será un placer. Muchas gracias a todos y que sea un éxito estas jornadas.
Muchas gracias al señor rector magnífico por su presencia hoy aquí. Entramos, diapositiva, por favor. Una vez más, las actividades que promovemos desde el Grupo de Investigación de Referencia Competitiva de la Xunta de Galicia, Empresa y Administración, reciben el apoyo institucional del señor rector. Sabemos que podemos contar siempre con su colaboración y, una vez más, quiero expresar mi deuda de gratitud, que es de toda la Facultad de Derecho, para con él. Permítanme que, en nombre del equipo de investigación que integramos COGENS, les dé yo también la bienvenida a Santiago de Compostela. Una bienvenida que, lamentablemente, es virtual, en un año santo que habría debido ser el marco óptimo para que muchos vinieran a Galicia, por primera vez o con la insistencia de quienes ya la han conocido. Ganamos, es cierto, como indicaba el señor rector, con la posibilidad de que nos sigan personas desde muchos y recónditos lugares. Me enorgullece indicar que contamos con casi 100 inscritos españoles y más de 150 de allende nuestras fronteras. 29 países están presentes hoy en este congreso. Los resultados del proyecto COGENS llegan de esta manera mucho más lejos de lo que esperábamos cuando planteamos nuestro proyecto a la Comisión Europea. Y hablo en plural no porque haya accedido a la condición imperial, sino porque hablo en nombre de un auténtico equipo. Quienes formamos COGENS llevamos colaborando en las más diversas actividades más de una década. Hoy quiero hacer público mi agradecimiento sincero a Sylvain Lolon y a Marie-Cécile Descamps-Varniol, que unieron a las personas que hoy integran esta red y nos condujeron durante 3 proyectos de dimensión europea antes de pasarnos el testigo a Elisabeth Bramé-Schubert y a mí, con la imprescindible colaboración de Christophe Tessier desde Astres. En nombre del equipo, tengo que expresar, por supuesto, nuestro reconocimiento a la Comisión Europea. Con su línea de financiación sobre diálogo social, ha permitido que las actividades de COGENS tuvieran lugar. Hemos tenido el apoyo decidido a una investigación independiente, bien financiada, con unas pautas formales claras, pero un respeto absoluto de nuestra tarea como investigadores. Espero que hayamos estado a la altura del desafío. Hablaba de un equipo. Aunque ustedes me vean aquí solo y enmascarado en el Salón de Grados de la Facultad de Derecho, en el proyecto COGENS participan 15 Estados miembros de la Unión Europea, Turquía como Estado candidato y el Reino Unido. Procedemos de la Universidad Católica de Lovaina, la Carolina de Praga, la Universidad de Ciencias Aplicadas de Hamburgo, la Universidad Lumière Lyon 2, las de Cagliari, Luxemburgo, Maastricht, Ljubljana, Lund, Miño, Varsovia, Viena y la Universidad de Economía de Viena, la Universidad Católica Peter Pazmani de Budapest, la Babes Bolyai de Cluj-Napoca, el Magdalen College de Oxford y la Universidad Bilgi de Estambul. Y desde España, las universidades Carlos III y Rey Juan Carlos de Madrid. Y, naturalmente, nuestra ahora tecnológica, pero 5 veces centenaria, Universidad de Santiago de Compostela, que hoy tiene el placer de acogerles, siquiera virtualmente. Desde principios de 2019, nuestra investigación se ha articulado en torno a una reunión inicial de trabajo en Santiago, un primer seminario transnacional en Viena dedicado a los sujetos de nuestro tema y un segundo seminario transnacional en Lund a propósito de los contenidos. Quiero expresar aquí hoy también mi agradecimiento a Elisabeth Bramé-Schubert y a Franz Marhold en Viena y a Jenny Julen Bottinius en Lund por los espléndidos eventos que organizaron. En ellos, las presentaciones, el debate y el tejido de redes se combinaron de manera perfecta. La pandemia alteró, como comentaba el señor rector, radicalmente nuestros planes. Tuvimos que cancelar nuestros comités de pilotaje en Braga y en Varsovia, pero mi agradecimiento a Teresa Coelho Moreira y a Łukasz Pisarczyk no es menor por ello. Sé que todo habría funcionado a la perfección, creando las condiciones ideales para la discusión. Nuestra conferencia final, que hoy y mañana se desarrollará de forma virtual, habría debido reunir en Santiago de Compostela a casi 100 especialistas, académicos, interlocutores sociales, partes implicadas, agentes gubernamentales. Hoy nos reúne de forma virtual a más de 250 participantes. Muchas gracias, de corazón, por su interés en nuestra investigación. Cedo la palabra a Elisabeth Bramé-Schubert.
Muchísimas gracias, Chema. First of all, a very warm welcome to all of you and a big hello from Vienna. I would like to support everything that the Rector Magnifico said about thanking José María for all his work that he has done in this project. And I think that I'm not only speaking for myself, but for the whole equipe. Big thank you, José María. You've done a terrific job. You coped not only with me, but with all of us, and you realized, or you managed to bring us all here together today and tomorrow. So a big thank you from the whole equipe to you. So ladies and gentlemen, this is the wrong slide. I am sorry. We're still with the general slides on the scientific approach.
Just correcting it. 1 minute.
Perfect. So what I'm going to do in the next 2 minutes is that I'm going to explain to you the scientific approach of our project. And I'm just going to start with presenting, because I believe in the force of the spoken word, as Franz Mahardt uses to say. So the goal of the project is actually to explore whether, and if so, how, collective bargaining agreements could provide a means for guaranteeing at least some labor protection for persons working in the gig economy, taking for granted that most of the persons, or many persons working in the gig economy, are actually not classed as employees, in the sense that the whole corpus of labor law applies. So unlike other research in the gig economy or on the gig economy, this project takes for granted that many persons working in the gig economy are not classed as employees. And it aims at shedding some light at their actual or potential collective labor rights. This entails, first of all, that we had a look, and we're also going to have a look today and tomorrow, at the evaluation of the bargaining agents in the different member states. We had a look at the question, and we checked whether established actors actually took the field, so established unions that existed for more than 100 years, whether they participated in the dynamics of the gig economy, or whether they are being substituted totally or partially by new agents. Interesting best practices can be drawn from the comparison between the 17 countries presented, raising awareness, especially in those countries that are kind of being left behind in the dynamics of the gig economy. Yet we did not study actors only, but we also had a look into the contents of actual collective bargaining, of actual best practices that are similar to collective bargaining. And we undertook that endeavor in order to check the suitability of real collective bargaining in the gig economy. A theoretical approach revealed that digital contents, of course, could be identified. However, thank you very much, the practical experience showed that the old bargaining actors, as well as new bargaining actors, also then started to bargain on classical topics of collective bargaining. What do I mean, or what do we mean by classical topics? Naturally, topics such as wages or paid holidays. And above these two topics, namely actors and contents, the kind of the umbrella meaning as a plurality of sources stands. What we did, and what we are going to do in these 2 days of the project, is that we did not study only collective bargaining stricto sensu, but that we also had a look at alternative sources of bargaining, meaning, for example, the acuerdos de interés profesional in Spain, or the different charters that started to exist and kind of developed in France, or code of conduct, paid crowdsourcing for the better, an example from Germany. Thank you very much, and I think that I'm going to hand over the floor to Christoph.
Thank you, Elisabeth. I don't know if we have the slides also. No, it's not a problem. Okay, I just want first let me say I'm feel really frustrated not to be with you all in this project, as the 𝖫 network and this COGENS project beyond alongside the scientific approach and studies and work carried out is also a fantastic opportunity to share many good moments and brilliant reflections with brilliant brilliant people, and I want to repeat how thankful I feel to all the project teams and to Jose Maria, who proved to be a fantastic project leader in all dimensions. So let me say, I hope we'll have other opportunities to share good moments all together and to go further in our investigations about the future of work. Stakeholders covered by the COGENS project, that is, in a way, the target groups of our project. Of course, we are talking about collective bargaining in the so-called gig economy or platform economy, and as such, we are to cover a set of very different stakeholders and stakeholders. First, and of course, traditional social partners are at the core of traditional and collective bargaining process at different levels, and as such, they are covered by our projects. That is, unions, of course, traditional unions who have to cope with ways to organize and represent the interest of new atypical workers, self-employed workers, and also fragmented workers. And of course, employer organizations and employer representatives, as we all know, platform economy is also a phenomenon leading to change the patterns of traditional business models and traditional business models in many different sectors. Just think about transports, for instance. So traditional social partners as the natural agents for collective bargaining of course, at the core of our project. But they are not alone. Business organizations organize, as Elizabeth said, we all know that platform workers are often self-employed workers, and as such, they may be, or they are represented by business organizations at different levels, trying to organize and to represent on-account workers, freelance workers, self-employed workers in general. So those business organizations are also some of the stakeholders interested in collective bargaining issues regarding gig workers. Third category of groups or stakeholders covered naturally by our project are those what we call emerging entities, emerging groups, that is, grassroots organizations aiming to organize and represent gig workers. Those grassroots organizations come from gig workers themselves, alongside trade unions who have been trying to organize by themselves in a way to defend their interests collectively in their relations with the platforms. And of course, they should be, or they are already, to be considered as possible new agents for collective bargainings alongside trade unions or with trade unions. So it's an issue as such. Of course, collective, when we're talking about collective bargaining in the gig economy, legal practitioners are also interested in it. We all know that across Europe, many litigation occurred related to employment status, I would say, of gig workers. So lawyers, judges, courts are all relevant actors in those matters, and we can assume that the possible development of collective bargaining for gig workers could lead to further or new litigations, and so justify the interest of lawyers and judges. And at last but not least, of course, talking about collective bargaining for gig economy, we are also talking about new forms of work, new business models, the interaction of different scientific approaches, both legal, sociological, economic approaches to try to identify and to address the different issues linked to those new ways of working, to those new forms of atypical work, and also at the same time to those new business models linked to the development of platform economy. So all of these stakeholders, and you can see that they may be very different from each other, are to be covered by our project. And I think I have to leave the floor to Jose Maria again. Thank you.
It's Elizabeth?
Elizabeth, sorry. Excuse me, Elizabeth. I'm a bit confused.
No worries at all. So it's my turn now to present to you the outcomes, or at least what we tried to do in the Vienna seminar, which took place 2 years ago. So in the Vienna seminar, where around 50 persons participated, we undertook the endeavor to study the personal dimension of collective bargaining in the gig economy, who and for whom. What we did in the first day is that we studied the supranational sources of collective bargaining in the gig economy, where we looked at the European level, namely the European Union level, but also the Council of Europe level. And we're very grateful that one of our project members, namely 𝖫𝐵𝐴, is also a member of the European Committee of Social Rights with the Council of Europe. And she gave us a very interesting presentation on the case of the Irish Congress of Trade Unions versus Ireland of 2018. And if I'm not completely mistaken, she's also going to present parts of it again during this conference here. So in these 2 days, the basic question was whether self-employed workers should or could also enjoy the right to bargain collectively. However, it was not only our project members or partners who presented in the Vienna seminar, but also stakeholders from international organizations such as the ILO, for example. In this first panel, Hannah Johnston from the ILO presented some findings which were actually quite interesting too, because Hannah Johnston reported of a kind of a new approach from the United States, where at the LaGuardia Airport in New York, it was the idea was born to open up the kind of level of representation of the company or of the firm, so firm level or company level, to open it to the whole city, so that the company was not that the company at the specific site, but that kind of the level of representation of bargaining was actually the city, so the city boundaries, the city frontiers. Actually quite interesting approach as regards the level of collective bargaining. What we also did in the Vienna seminar is that we studied old actors and new agents. And I am sorry if I cannot imagine, due to time reasons, all the persons that participated, but that I'm only highlighting some presentations here. One that was very striking was the one from Odile Chagny from France, who presented different alternative approaches of organizing persons working in the gig economy, for example, joint ombuds offices, cooperatives, networks, etc. So she opened the eyes of us academics to new approaches that had taken the floor in practice. When studying which actions to be taken for whom, we looked at the question of whether existing sources should be adapted or whether new sources should be adopted, either by case regulations or by principles. And it was mainly Pierre Aloi from the University of Cagliari who reported on this topic. Luca Ratti gave a very interesting presentation on crowd working, generally speaking, and as regards industrial action, which is also a phenomenon that has taken place in the gig economy in some countries quite frequently. I would only like to give the examples of Germany and the UK. Zane Raznacha from the European Trade Union Institute gave us a very interesting presentation back then in Vienna, also already via a video. And one very interesting point that Zane highlighted was that information and consultation practices as collective rights should also be guaranteed to gig workers. And she presented the idea of creating kind of safe spaces for gig workers where they could interact with each other, but also with, for example, the platform owner. And this idea is, I think, quite interesting because we all know that platform workers don't meet regularly at the office at the same place in order to consult, inform with each other. So creating these safe spaces might be an idea to follow. This first day was then followed by a second day of roundtable sessions where we invited practitioners, stakeholders from different organizations to share their experience with us. And these roundtables included speakers such as Nicola Kontouris, back then from the University College of London, now with ETUI, with an interesting suggestion as regards payment of gig workers. Nicola suggested that instead of paying gig workers hourly rates, we should think of, or the path should be explored, whether payment should be a weekly payment in order to prevent fragmentation of work. Another roundtable consisted of Austrian stakeholders where special focus was put on the level of bargaining. And the Austrian stakeholders agreed that the most apt level of bargaining for gig workers would be the company level. However, as we are going to see during this seminar, this is not shared by the experiences in all countries, in all member states. As we're going to see, for example, in Italy, there has been some movement as regards bargaining at the branch level. The panel of the international stakeholders, to conclude with, consisted of representatives, again, for example, from the ETUC, but also one representative from the Bologna Riders Union, who presented us the Bologna Riders Charter, which actually has no legal effect, but which actually works as template or framework for local bargaining. And I think this is also one takeaway of our project, that even if not collective bargaining stricto sensu, with erga omnes effects, for example, is achieved, perhaps other means or alternative sources of bargaining, charters, etc., can actually work as at least as templates or as frameworks for then real collective bargaining. In the end of the Vienna seminar, we took an outlook to the Lund seminar, where then actually contents of collective bargaining in the gig economy were studied.
Christophe?
Yes. I don't have the slides. Okay. So yes, our second Jenny will present later on a report about the objects of the second transnational seminar held in Lund in December 2019. So just before the pandemic froze everything. And so the question is, if you think to collective bargaining, the general question was, if you think to collective bargaining, what would be the content of collective bargaining process? And what we saw, of course, that there were some traditional of collective bargaining fully relevant to gig economy workers, and those topics are not original or not new as such, and among them, of course, and they are at the basis of many litigations regarding gig workers, is working time, time sovereignty, or remuneration, of course, and decent remuneration, and minimal remuneration, and change in remuneration and working time, and so on. Of course, health and safety issues, which are at the core of the concerns of many so-called gig workers, especially in the transport. Think about, of course, the couriers. We have many and unfortunately examples of accidents at work involving couriers and so on across Europe. And so, of course, health and safety is a major issue for gig workers. Social protection, which is not necessary, is at stake, because as self-employed, gig workers do not enjoy all the rights employees may and to social protection, especially regarding protection in case of work accidents or protection in case of unemployment, just for instance. So social protection is naturally a very central topics when thinking about the protection of gig workers, and it could be, or it may be addressed through collective bargaining of process or new forms of collective discussions of negotiations, as it's already the case in some countries. Collective rights as such are already and of course a matter for discussion. It's at the core of our project. The right to join collective organizations, the right to unionize, the right to be represented and to present some claims and to be protected for this are of course linked to the issue of collective rights of gig economy workers and the right to strike, of course, in a way. Beyond, I would say, those traditional topics for collective bargainings, which are not so different finally than those related to traditional employees, there are new topics or contents which require full attention and which are specific in the way, because they are linked to the way we're organized under platforms. That is the data protection of workers, the portability of data related to workers and to the work they carry out for platforms, the issue of the algorithm and the algorithmic management, which change the way work is organized and require for more transparency, probably for workers. So all those issues which has become really prominent in nowadays are of course directly linked to the digitalization as such of the work carried out through platforms. So that was all of the issue discussed, and again, Jenny will present more precise in later on in the conference. But finally, the question is, which is the minimum protection for gig economy workers, which should be defined at collective level? That is a question. Collective bargaining is not, of course, the only instrument to be considered in this respect. Of course, there is place for it in legal sources, in the regulation of social security systems, but collective bargaining has probably a role to play in respect of all of these issues. That's all for a short introduction.
Me corresponde a mí poner fin a esta sesión de presentación de nuestro proyecto, cuyos resultados serán expuestos hoy y mañana con detalle. Permítanme que les ofrezca no un aperitivo, que sería alcohólicamente impropio de una hora tan temprana, sino un segundo desayuno antes de entrar en materia. La diapositiva, por favor. Como pueden ver, ilustramos nuestra primera reunión en Santiago de Compostela con la Torre de Babel de Bruegel el Viejo, un cuadro que se encuentra en el Kunsthistorisches Museum de Viena, sede de la universidad que codirige este proyecto. En primer lugar, porque percibíamos que había una gran diferencia entre los estatus de poder de las plataformas y quienes les prestaban servicio, como ilustra metafóricamente la parte inferior del cuadro. Existía, además, a principios de 2019, la sensación de que la economía de plataformas podía estar construyendo algo colosal pero inseguro, como la propia torre pintada por Bruegel. Bastaba con ver las capitalizaciones bursátiles de estas empresas que desafiaban al mercado tradicional con su nuevo modelo de trabajo. Y al hablar de Babel, íbamos también al futuro del cuadro, a la división de las lenguas tras la destrucción de la Torre de Babel. Y es que el lenguaje, al tratar la economía de plataformas, ha evolucionado muy poderosamente desde que Jeremiah Adams Prassel llamó nuestra atención por primera vez sobre este fenómeno en Lyon en la conferencia de clausura del proyecto 𝖫 en 2016. Fue la primera vez que yo oí hablar de Deliveroo y jamás pensé que me cruzaría con una bicicleta en mi camino. El término economía colaborativa ha desaparecido del mismo modo que desaparecieron los muros de la Torre de Babel. Pero sigue habiendo algo orwelliano en la terminología de este modelo de negocio, como se fue viendo en nuestros sucesivos seminarios. Se habla de supercolaboradores en lugar de trabajadores. Se habla de la desconexión en lugar del despido. Me permito recordar que retirar era el término que se empleaba en Blade Runner para la ejecución de los replicantes, por cierto. Nuestra segunda actividad, el fantástico seminario que tan brillantemente ha presentado Elisabeth antes de mí, en la 𝖫𝗎ti𝗈 Wien, en junio de 2019, tuvo como icono, como pueden ver en la diapositiva, al primer autómata. Quizás el más célebre de todos, si exceptuamos a Mazinger Z y a R2D2. Se trataba, por supuesto, del célebre turco mecánico de los tiempos de la emperatriz María Teresa. Hoy en día, su nombre perdura en la herramienta de crowdwork de Amazon. Pero en su momento, este turco despertó el asombro de Europa, incluso de los Estados Unidos. Una máquina que jugaba al ajedrez, hasta contra Napoleón, después de la batalla de Wagram. Pero la ilustración que escogimos para presentar nuestro seminario es la de Joseph Rachnitz, que se conserva en la biblioteca de la Universidad Humboldt de Berlín, donde precisamente nació ese modelo universitario de docencia e investigación que COGENS encarna a la perfección. En esta ilustración se intentaba plasmar la que parece la explicación más verosímil sobre el turco mecánico. Dentro del autómata había un hombre. Dentro de las plataformas también. No se trata de una aplicación solo. Se trata de una aplicación y los humanos que con su mediación imprescindible prestan sus servicios, como ha subrayado la jurisprudencia del Tribunal de Justicia. En ese primer debate, que Elisabeth Schubert ya ha avanzado y que desarrollará a continuación, constatamos los distintos sujetos que podían participar, hipotética o realmente, en la representación de los trabajadores de las plataformas. Por un lado, nos lo ha indicado Christophe también, se buscaban nuevas vías de expresión, propiciadas por las personas que prestan sus servicios desde las plataformas. Han surgido agrupaciones, cuentas de WhatsApp, grupos de WhatsApp, perfiles de Twitter, que cambian de responsable con tanta facilidad como cambiaba la identidad del pirata Roberts en La Princesa Prometida. El Twitter permanece, la persona que lo maneja es ya otra. Aquí viene la seguridad del anonimato para expresar esa opinión, que recuerda, a mí por lo menos, al hombre que fue jueves de Chesterton cuando reflexionaba sobre los orígenes del anarquismo. Pero un perfil anónimo no negocia un convenio colectivo. La realidad ha respaldado esta afirmación. Existen acuerdos de sector, como los firmados por UGT y comisiones obreras en España para la hostelería, o por CGIL e CESIL en Italia para la logística. Existen acuerdos de empresa, como el suscrito por 3F en Dinamarca con Hilfer.dk o por GMB con Hermes en el Reino Unido. Recurriendo al inmortal cuento de Augusto Monterroso, el más breve de la lengua española, cuando se despertó, el dinosaurio seguía ahí. Y es que la posición dominante de las tradicionales formas de representación es un hecho. Gozan de un auténtico monopolio en la negociación. Y es que no en vano, recordemos, los dinosaurios dominaron la Tierra durante milenios. En nuestro caso, no va a haber meteorito, pero la necesidad de adaptación de la que hablaremos en este congreso es imprescindible para su supervivencia. Pasamos. En nuestra tercera actividad, en Lund, nos centramos en los contenidos, posibles o reales, de esa negociación colectiva que estábamos explorando. Christophe Tessier ya ha expuesto nuestras principales conclusiones y mañana hablaremos sobre ello con detalle. Ahora quiero llamar su atención sobre este espléndido grabado, Suecia antigua et odierna, Suecia antigua y actual, de la segunda mitad del siglo XVII, que se conserva en la Biblioteca Real de Estocolmo. Si contemplamos con detalle esa ilustración, vemos que hay vehículos de transporte, hay repartidores, hay servicios domésticos, hay servicios financieros. El edificio grande que ven es el Banco Real fundado por Gustavo Adolfo. Estamos viendo en el siglo XVII las mismas actividades offline que ahora se prestan a través de plataformas. Y no puedo dejar de subrayar la actividad de limpieza domiciliaria que tanta importancia tiene en algunos Estados miembros. Al asomarnos a ella, a través de ese convenio en Dinamarca al que me refería antes, percibimos que afectaba a colectivos feminizados con una importante presencia de trabajadoras migrantes. Colectivos, por lo tanto, sometidos a una doble vulnerabilidad. Las plataformas podían estar dando lugar a una nueva cuestión social, a un nuevo precariado más allá de los trabajadores tradicionales. Las plataformas son, pues, el marco en el que resucitan viejos asuntos. ¿Y dónde estaban los que no veíamos? ¿Dónde estaba el crowdwork? En aquel seminario de Lund empleé una metáfora que vuelvo a utilizar hoy. El trabajo masivo online es la cara oculta de la luna. Han surgido, por supuesto, iniciativas de representación en él, impulsadas por una feliz unión de trabajadores y doctrina, pero la tierra desconocida supera con mucho lo que hemos podido aprender del trabajo offline. Los contenidos de la negociación colectiva en una economía digitalizada, a la que hacía referencia el señor rector, son el reto del futuro, porque ya no solo afectan a conductores o a traductores online, nos afectan a todos, como pone de manifiesto el Acuerdo Europeo sobre Digitalización de junio de 2020. Lanzo aquí mismo el guante a mis compañeros de proyecto para que en un nuevo marco de investigación acometamos esta tarea. Y llegamos finalmente a nuestra última ilustración. La imagen no necesita presentación, la fragua de Vulcano, del genial Velázquez, el más grande de los pintores españoles. Todas las imágenes que hemos utilizado, por cierto, están en el dominio público o cuentan con las correspondientes licencias de uso. Apolo entra en la fragua de Vulcano para anunciar a este el adulterio de su esposa Venus con el belicoso Marte. No vamos a hablar de ello en este congreso, aunque Botticelli lo ilustrará primorosamente. Velázquez pinta a dioses con la apariencia de humanos, trabajando con independencia de su naturaleza. Da igual que sean dioses u hombres, la noticia les afecta por igual, y de la misma forma, humana o divina, desempeñan su trabajo. Parece que ese es el rumbo que está tomando la negociación colectiva mixta impulsada desde la Unión Europea. Cuando iniciamos nuestra tarea en COGENS, la sentencia Kunsten la prohibía terminantemente. Pasados 2 años de trabajos, estamos en el camino de asistir a un giro copernicano en este sentido, o al menos al inicio de una discusión de calado sobre este tema. Una negociación colectiva que obligue a asalariados y autónomos hará superfluo, en cierta manera, el debate sobre la naturaleza de las personas que trabajan en plataformas. La negociación colectiva podría transformarse así en la herramienta óptima para el establecimiento de un suelo pactado de condiciones decentes de trabajo. Apolo lleva en persona la noticia a la fragua. Y es que el amigo de las musas no usaba Twitter. Al principio de nuestra investigación, muchos de nosotros tampoco. Éramos juristas clásicos, de boletín, de recopilación de sentencias, de manual, de comentar en el sentido alemán. La economía de plataformas desafía con su naturaleza motorizada las fuentes tradicionales de información. Su ámbito de vida natural, Internet, la red, es su propia biblioteca. De hecho, creamos un blog al inicio de nuestro proyecto y pronto fuimos conscientes de que era una herramienta que se quedaba obsoleta para lo que queríamos. Aporta más al conocimiento en esta materia un perfil de Twitter que comparte y produce informaciones relevantes que la reproducción en PDF de una norma en un archivo estático. Quiero expresar aquí otro agradecimiento más a Daniel Pérez del Prado por su tarea anónima detrás de nuestro perfil compartido. Invitamos, naturalmente, a todos los participantes a tuitear todo lo que deseen sobre el contenido de nuestro congreso. Y no duden ni olviden etiquetarnos. Si se quieren conocer las novedades en este campo, es mi impresión, ya no cabe el recurso al diario oficial. Salvo en el caso de España, por otra parte, que ha dado un primer paso, medido pero importante, en la regulación legal del trabajo en plataformas. Los tribunales de justicia han tenido un papel mucho más decisivo de lo que concebimos al iniciar este proyecto y a ellos dedicaremos un panel monográfico. En este congreso final, junto a los integrantes de nuestro equipo de investigación, tenemos 3 paneles de invitados. El primero de ellos, esta tarde, se compondrá de interlocutores sociales, continuando nuestra línea de trabajo a la que nos comprometimos con la Comisión Europea. Recibimos, además, indicaciones para que intercambiáramos nuestros puntos de vista con otros proyectos de investigación similares al nuestro. Constituirá el segundo panel mañana. El tercer panel invitado lo integran los textos seleccionados de nuestro Call for Papers. Sus aportaciones, publicadas en el Hungarian Labour Law Journal, están a su disposición en el número 2 de 2020, del que compartiremos el enlace mañana en la correspondiente sesión. Gracias a 𝖤𝗎ti𝗈 𝖠 y a 𝐵𝐵 por su tarea de edición. En 3 de nuestros 4 carteles hemos utilizado la letra ácelas. Y es que las manos del rey son manos que curan. El derecho del trabajo, la encarnación de ese poder soberano que pasa del rey de Babel al León del Norte, a María Teresa y llega a nuestros parlamentos, es la herramienta que podrá regular en condiciones decentes el trabajo en plataformas. La finalidad protectora con la que nació la legislación laboral vuelve a manifestarse en todo su significado. Y la negociación colectiva está llamada a desempeñar un papel central en ese escenario. Este congreso, termino, es el final del camino de COGENS, de la misma manera que Santiago es el final del primer itinerario cultural europeo, construido sobre una historia compartida, de la misma forma que nosotros hemos intentado hacer con nuestro proyecto de investigación. Pero el camino sigue y sigue, y termino expresando mi deseo de que podamos continuarlo juntos. ¿A dónde nos llevará? No sabría decirlo. Cedo la palabra a Elisabeth Brammer-Schubert para la presentación de su informe de síntesis. Muchas gracias.
Muchísimas gracias, José María. Shall I wait for the slides, since apparently I am not in the position of sharing them? Yes, so many thanks also for the splendid presentation of our images. So, ladies and gentlemen, on the first presentation as regards the content of this conference is on collective bargaining and the gig economy and the actors and their personal scope. As we have already heard today and during the whole project, it is a given fact that persons working in the gig economy are only seldom classed as employee. Rather, they are working under different statuses in the different member states or states that we're covering here. And I'm deeply sorry for the UK and Turkey if I'm referring to the member states in the following 20 minutes. It's not that I want to exclude you, but it takes quite some time to then always refer to the UK and Turkey too. So my apologies for that. So, and next slide, please. Next slide, please. Thank you. And one more click. Perfect. Once more, just the whole slide. I introduced some animations, but let's just see the whole slide, please. Yes, perfect. And so they work on the different statuses in the different member states, and I try to highlight the status in green. So this status is often an in-between status, a status between employees who enjoy the whole corpus of collective or of labor rights, including collective labor rights on the one hand, and the status of self-employed who only seldom enjoy labor rights. Sometimes they enjoy some social protection rights. This existence of this third or in-between status is also acknowledged by the European Commission in its first phase consultation document on platform work. And I would like to quote the Commission here. It states that some trade unions have opened their membership to non-standard workers and the self-employed and have started campaigning for the rights of people working through platforms. A few innovative collective agreements have also recently been signed between unions and digital platforms, but they remain very limited. This quote already shows us the direction that we are headed to in our project, and that I would like to approach today too. Namely, the questions are the core questions. Next slide, please. Whether gig workers can organize, who bargains for gig workers, and whether there are differences as regards the factual and the legal situation in the member states. Next slide, please. So in the following 20 minutes, ladies and gentlemen, I would like to take a closer look at who is bargaining for whom, especially as regards those persons who have this in-between status, and I try to come up with an acronym for them, namely for persons who are economically dependent, employee-like workers. We're going to have a look at whether these persons, or persons that can be grouped under this title, enjoy collective labor rights in the member states. After that, and after trying to map a picture of different collective labor rights of this group of persons, we're then going to have a quick look at two initiatives of the European Commission addressing the core questions that I've just referred to, namely the European Commission's initiative on collective bargaining agreements for self-employed and the scope of application of EU competition rules. Nota bene that this initiative comes from from DG Competition and not from DG Employment. The second one, the EC's first phase consultation of social partners under Article 154 TFEU on possible action addressing the challenges related to conditions in platform work is actually from the DG Employment then, and we are shedding some light at questions regarding collective rights for platform workers addressed in these two initiatives. So, ladies and gentlemen, let's start with the question of bargaining for whom. Who works in the gig economy? Who are the addressees of collective bargaining? Who should enjoy or could enjoy or can enjoy collective bargaining rights? Next slide, please. So one potential approach could be, when we take for granted that many persons working in the gig economy are not classed as employees, one approach could be to take a look at the situations in the member states, and we have realized as team in this project that there exist quite some examples where collective rights, or at least some collective rights, are granted to a third category of persons. Third category, as I tried to show you on a previous slide, of persons that are in between employees and self-employed persons. And of course, there's no uniform definition of this third category of persons in the member states, nor is there a uniform definition at EU level. And Tamas Juhlavari is going to refer to that in his presentation later on too. What we tried to do as a team, or with the help of the team, we tried to find a kind of a distillation of the definitions in the different member states, of the definitions that are used in order to establish a framework for this third category of persons. And this distillation is that these economically dependent employee workers are persons who work primarily for one other person and or do not offer their services in the market, and who work in person with no or only a limited possibility of substitution. However, quite irrespective of which concrete criteria we actually apply, the core question as regards collective labor rights for this third category of persons is or should be whether they are, next kind of click please, whether they are in a weaker bargaining position towards their counterpart, towards the other side of labor, and whether they can influence their working conditions. Next click, please. And these are also topics that emerged in the European Committee of Social Rights sentence or decision on Irish Congress of Trade Unions, namely the weaker bargaining position and the lack of influence as regards their working conditions. Tamás is framing it or putting it quite frankly, persons who are in danger of social dumping with respect to their competitors and their partners. Next slide, please. So next clicks, please, so that we can kind of finish this slide. Several clicks, please. Yes. Perfect. Great. So one turn back, please. Thank you very much. So in 2019, at the very beginning of our project, we tried to map examples of collective rights, collective labor rights for persons working in the gig economy. And that's what we came up with in 2019. So 2 years ago, we found that in some countries, like for example, Germany and Spain, there exists some legal framework for collective bargaining or bargaining that is similar to collective bargaining for persons in between in the German Tarifvertragsgesetz or in Spain for the so-called trades. In other companies, there existed some best practice examples in, for example, the media center in Italy for call centers. However, this picture was quite a fragmented picture, as you can see. What we achieved in this project, together with our 17 project partners, we achieved to map or to draw a much more elaborate picture, as we're going to see in the following with the help of 7 or 8 slides. Next slide, please. And in order to achieve that picture, we asked our project partners, or together we discussed the following questions, namely whether collective bargaining agreements can be concluded for these economically dependent employee-like workers. We asked for the legal basis and the level of collective bargaining. We looked at the factual situation, whether collective bargaining agreements are actually concluded for this group of persons. We looked at the actors, at employers and employee side, and we also had a look at industrial action and whether there are any legal provisions that exist as regards industrial actions for employee-like workers who are economically dependent. Next slide, please. And I would just like to ask the person who is thankfully clicking the slides to just show us the whole slide. Thank you very much. So there are several member states where a formal recognition of a special status guaranteeing some collective labor rights exists. Nota bene, please, that this does not necessarily entail collective bargaining stricto sensu. Yet in some countries, there actually exists the possibility of real collective bargaining. What do I mean with real collective bargaining? Collective bargaining with the same effects as collective bargaining for employees entails. Examples for this real collective bargaining for platform workers with an in-between status exist in Germany, for example, in Italy via widely interpreting Article 39 of the Italian Constitution, which recognizes the right to collective bargaining. It is, for example, this Article 39 of the Italian Constitution is said to have a wide scope of application and therefore can also be interpreted as comprising collective bargaining for self-employed or at least for economically dependent self-employed. Also in the UK, real collective bargaining rights exist not only for employees but also for workers, so these persons who enjoy a specific status, which is not a status of employees nor a status of independent contractors. In other countries, such as the Netherlands, for example, collective bargaining agreements or their scope of application can be extended to persons in between, so to our gig workers. Yet, and I'm going to refer to the Netherlands in some seconds again, there are some difficulties as regards the actual extent of collective bargaining agreements. In other countries, other collective labor rights exist. For example, in France, according to the 𝖫𝐸𝐺 Act, according to the 𝖫𝐸𝐺 Act, a specific status is actually acknowledged, and according to the status, persons enjoy some collective labor rights, at least. In Spain, on the other hand, also a formal status, a specific status of persons in between is recognized, the status of trade, and these trade can actually conclude collective contracts under civil law, so-called professional interest agreements, which are not real collective bargaining agreements, but which are classed as at least a specific collective labor right. Next slide, please. In other countries, also a specific status is recognized, yet no collective labor rights are granted. Examples for these countries are, for example, Austria, Hungary, or Portugal, where some other rights, like, for example, equal treatment or occupational health and safety, insurance against occupational or work-related accidents are granted, but no collective labor rights are guaranteed. In other countries, like, for example, Belgium, it is uncertain whether labor law in general applies to these persons in between. In countries like Slovenia, for example, there is, or persons with that specific status can be, if they request for the recognition of such a status, can be recognized. And if such a request actually takes place of recognition of this specific status, then as regards the working conditions, the level of remuneration of the collective bargaining agreement in the respective sector needs to be respected. Yet there is hardly any information as regards the actual request of persons for recognizing the status, so we cannot say for sure whether collective bargaining agreements are actually respected as regards the wages of these persons. Next slide, please. In some other countries, traditional trade unions or specifically created organizations have started to bargain or to actually engage for gig workers. The prime example is the United Kingdom, where the Independent Workers' Union of Great Britain is very much into actually representing gig workers, but also established unions are increasingly becoming interested in representing gig workers. Next slide, please. In other countries, so that is kind of the downside, there is still just a bipolarity of collective labor relations existence. What do I mean by that? By bipolarity of the collective labor relations in the member states that you can see on the slides: Portugal, Luxembourg, Austria, the Czech Republic, Hungary, Romania, Turkey. No such specific status guaranteeing any collective labor rights exists, meaning that collective labor rights are granted to employees only. They are not granted to self-employed nor to any persons of an in-between status. Next slide, please. In other countries, collective bargaining agreements can be actually declared applicable to our economically dependent employee-like workers, to these persons in between. And the prime example for that is the Netherlands. Yet, the problem with the Netherlands is, and I'm not telling you anything new here, is that it was actually the Dutch case from 𝖤𝖨 that was decided by the Court of Justice, and which Tamás Gyulahvari is going to refer to in his presentation shortly. It was the Dutch case, or the European Court of Justice's case in 𝖤𝖨 that led to a quite difficult situation in the Netherlands, which means that actually from the law, theoretically, it would be possible to actually declare collective bargaining agreements applicable also to persons who are not employees. Yet in practice, everyone is waiting for a response by the government or by the legislator to the 𝖤𝖨 judgment, because actually, apparently, the judgment is read in a way that this declaration of to actually declare collective bargaining agreements applicable also to persons who are not employees is deemed to be unlawful after the 𝖤𝖨 judgment by the Court of Justice. Next slide, please. As regards the level of conclusion of collective bargaining agreements for persons in between, we found out that in some member states there's actually a problem of representativeness, like for example in Italy. In other member states like the UK, collective bargaining agreements for our gig workers are concluded at company level primarily. In other member states like Slovenia, where an important example or an important exception exists actually for journalists, so for decades, collective bargaining agreements can be actually concluded for persons in between, so for economically dependent employee-like workers who are journalists only. So we see here that the media sector, especially for journalists, is kind of a very specific sector. So here in Slovenia, this collective bargaining agreement is concluded at branch level. Next slide, please. We also found out that in some member states, there exist actually special agreements without the same effect as collective bargaining agreements, or as kind of collective bargaining agreements for real employees have, especially without an erga omnes effect. The prime example is the Spanish example for trades, where these professional interest agreements can be concluded for these trabajadores autónomos económicamente dependientes, for the trades. These professional interest agreements are agreements under civil law without the same effects as collective bargaining agreements enjoy. In the Netherlands, there also exists one specific agreement concluded in the restoration sector without the same effect, but which guarantees at least some protection as regards employment conditions. In France, representation at branch level exists with the aim of a social dialogue. Social dialogue, of course, without entailing the same effect as collective bargaining agreements for employees. Next slide, and this is the last slide, so you can actually see that the picture that we were able to draw within this project is a very diverse one and a very large one, is that in several countries, gig workers or persons in between also actually involved in industrial action, or at least exists the legal possibility to be involved in collective bargaining or in industrial action. In Italy, for example, this right of collective action is guaranteed by Article 40 of the Italian Constitution, that again needs to be interpreted in a wide way. In other countries, like for example Germany or France, gig workers were actually involved in collective action. Next slide, please, ladies and gentlemen. Thank you very much. So this brings me to my assessment. So the picture that we were able to draw in this project or within the project is a very diverse one. In addition, also taking into account the Commission's initiative on platform work, we can state that platforms also work transnationally or often work at a transnational basis. So the question is whether an action at EU level could be appropriate or would be appropriate, taking into account the very diverse picture that we have just drawn and also taking into account the transnational operation by platforms. Next slide, please. So what did the Commission actually do, or what does the Commission actually suggest? Actually, it also suggests action at EU level, and this comes in two ways, this action at EU level. The first one is the European Commission's initiative of collective bargaining agreements for self-employed as regards the scope of application of competition rules. This initiative actually derives from the DG Competition, and the primary goal or the sole goal of this initiative is to clarify that collective bargaining agreements concluded for nota bene solo self-employed, so for a very specific group of persons, do not infringe EU competition law. The goal is to implement this initiative via either council regulation or via a Commission communication. Next slide, please. The Commission states that its goal is to ensure that EU competition law does not stand in the way of initiatives to improve working conditions through collective agreements. For solo self-employed, where they choose to conclude such agreements while guaranteeing that consumers and SMEs continue to benefit from competitive prices and innovative business models, including in the digital economy. This shows that the Commission is actually aware of the fact that in several member states, and we've seen the examples like, for example, in Germany or in Italy, there actually exists the possibility of real collective bargaining for persons who are not employees. And actually the Commission took now the initiative of clarifying in the aftermath of the 𝖤𝐵 judgment, especially of clarifying that collective bargaining agreements concluded for solo self-employed should not and do not infringe EU competition law. The question, however, is, ladies and gentlemen, that I'm asking myself, next slide please, is the question as regards the personal scope. The question is why the Commission refers to solo self-employed only, and it also gives us a definition of these solo self-employed. It means by solo self-employed, self-employed without employees. However, as we found out in our project here, is that collective bargaining agreements that can be concluded for persons in between in the member states not necessarily only comprise these solo self-employed. In some countries like Germany, for example, there also exists the limited possibility for these persons who for whom collective bargaining agreements can be concluded to actually also use substitutes in a limited way. The background, however, is that actually, apparently, at least according to a study carried out in 2016, and that also the Commission refers to in this initiative, is that solo self-employed are apparently at a higher risk of precariousness compared to self-employed with employees. Other definitions, I personally speaking would deem more appropriate compared to this definition of solo self-employed, are definitions that take into account the weakness in bargaining resulting from economic dependency, which can also be taken from the CJEU's judgment in 𝖤𝐵 that Tamás is also going to refer to. And I would like to cite its paragraph 33 of this judgment, because the court holds that a service provider can lose his status of an undertaking. So therefore, at least in the way I read the judgment, can also be or can also fall under the scope of a collective bargaining agreement without infringing Article 101 TFEU. So a service provider can lose the status of an undertaking if he does not determine independently his own conduct on the market, but entirely dependent on his principal because he does not bear any of the financial or commercial risks arising out of the latter's activity and operates as an auxiliary within the principal's undertaking. This reference to solo self-employed is then also reflected by the 4 policy options that the EU Commission gives us in its initiative. Next slide, please. These policy options all refer to solo self-employed and show that the Commission envisages 4 different paths as regards the exemption of solo self-employed from EU competition law. What I find kind of difficult with all these 4 policy options is that they all refer or through work via digital platforms. But what I find most, well, not strange, but difficult in terms of the principle of equality is the first policy option, according to which only solo self-employed providing their own labor through digital labor platforms should be exempt from Article 101 TFEU. That's the main problem I see with policy option 1. The other policy options then refer, and I deem, since the Commission also realized that there might be troubles as regards the principle of equality, the other policy options not only refer to solo self-employed working through digital platforms, but also working as professional customers of a certain minimum size, without minimum size, etc. Next slide, please. The second initiative I would just like to highlight here, since I'm running out of time, is, or where I just want to highlight some points from, is the European Commission's initiative on a first phase consultation of social partners under Article 145 TFEU on possible action addressing the challenges related to working conditions in platform work. Those who think that, well, this is actually what we've been doing here in our project, well, I'm sorry, I have to disappoint you, since the Commission actually acknowledges that it does not address the topic of convergence of collective bargaining rights with EU competition law. The competition in this consultation mainly aims, as regards collective bargaining aspects, to consult the social partners and to study aspects of platform work that could lead to a support in social partners' coverage of platform work, to facilitate contacts between people working through platform works, and to promote social dialogue. Well, that's actually then what we also did in our project here when trying to invite and actually also give the floor to social partners, what we are also going to do in this very seminar here. Next slide, please. As the Commission states, social partners' coverage of platform work could be supported and social dialogues could be promoted. Opportunities for people working through platforms to discuss, share experiences and opinions could be established and actively encouraged, including the rating of digital platforms. The Commission also realizes and recognizes that digital platforms often work in a transnational way, and therefore proposes a common EU approach. The question that is also then handed to social partners in this first phase consultation and asked to social partners, whether social partners would actually consider initiating a dialogue under Article 155 of the TFEU. And what I really do hope is that we might also get an answer to this question in the framework of our conference here, since we're also going to welcome European social partners at one of the roundtable sessions here. I'm very much looking forward to the discussions as regards this first phase consultation document by the European Commission. And what I took from this consultation, next slide please, is whether we could actually think of, or whether this was also envisaged by the Commission, to actually have an EU framework agreement concluded according to Article 155, paragraphs 1 and 2, first alternative, TFEU. And I think this would be a most apt solution as regards collective bargaining and collective rights for persons in the gig economy. Why? Such a collective or such a framework agreement needs to be implemented via collective bargaining agreements according to the laws of each member state. So these framework agreements are actually not really EU law, and they cannot be implemented at EU level either, but they need to be implemented at national level in each member state, and therefore would also give space to this very diverse picture that we have seen in this very short presentation here, and that we also developed during this project. Yet, nota bene, please, too, that no implementation obligation exists. Prior agreements concluded under this framework are, for example, agreements on telework from 2002 or agreements on work-related stress. So agreements also on topics or phenomena that are cross-cutting topics and topics that were, at least back then, quite new topics. So taking into account the topics of these already existing framework, I think that a framework agreement on collective rights for gig workers would quite well fit into this line of prior agreements. The potential content of such an agreement could be, in my point of view, first of all, a definition of the personal scope, so a definition of those workers for whom collective bargaining agreements in the member states could be concluded without infringing EU competition law. So actually, such an agreement under Article 155 could bring together the Commission's two initiatives from the DG Comp and from the DG Employment. Such an agreement could actually create a definition of an intermediate category of working persons between employees stricto sensu and self-employed. And it could also suggest minimum wages, for example, other bargaining contents, minimum wages, for example, relative to national average wages, since, and that is a quite kind of a nice takeaway from these framework agreements, since these framework agreements are not actually bound to the restrictions as regards competences Article 153 TFEU gives us. So to conclude, ladies and gentlemen, and thank you very much for your patience with me. Next slide, please. To conclude, we could see that as regards collective bargaining, for whom and who concludes collective bargaining agreements, so as regards actors and the personal scope, the picture in the member states is a very diverse one. So no common definition of gig workers exists, no common definition of persons in between exists. The actors are diverse too. Traditional unions actually engage for gig workers, but also newly created platforms or organizations started to emerge. Therefore, and also taking into account the transnational way of how platforms operate, a common EU approach would be very welcome. It could clarify the scope of Article 101 TFEU, and a common approach based on a framework agreement under Article 155 TFEU could also define the personal scope of these persons in between, and then give the floor to the collective partners in the member states. And I would like to give the floor now, unfortunately not to lively discussions right after this talk here, but the floor to a short break, if I'm not completely mistaken, until 11:30. Next slide, please. Yes, I'm looking forward to lively and fruitful discussions during the whole conference. Thank you very much, ladies and gentlemen.
Muchas gracias, Elizabeth, por tu presentación excelente, como todo el trabajo que tú realizas, y que yo te quiero agradecer hoy públicamente. Estos 2 años y medio de colaboración contigo han sido absolutamente fructíferos y un placer. En efecto, tenemos ahora una pausa, pero como esto es un congreso que se desarrolla en España, no vamos a cumplir el horario. Nuestro equipo técnico necesita una bien merecida pausa, así que nos volveremos a encontrar a las 12 menos cuarto y no a las 11:30, como indica el programa. Media hora, por lo tanto, de pausa, y volvemos a encontrarnos con la elección para ustedes entre el panel A y el panel B. Muchísimas gracias a todos por sus intervenciones y nos vemos en media hora.